G'day everyone and welcome to Laws 11061 Contracts A, Topic 6. This week we're looking at certainty and completeness, and I'm Anthony Marinac. This week we're looking at the last element that we have to examine in our study of formation of contracts. So to get to this point, we have looked at the fact that each of the parties who are proposing to make a contract actually has the capacity to make a contract. We've looked at the fact that they intend to make legal relations between them. We've looked at the offer and acceptance between them and made sure that the parties are ad idem. And then last week we looked at the fact that consideration has been given and received as between the parties. The last thing we need to do is consider what we call certainty and completeness. Certainty and completeness are distinct concepts, but they're very closely related, and we really deal with them almost in the same way when we're assessing contract formation. So what we're going to learn this week is first to identify whether a contract is sufficiently certain, and if it's not sufficiently certain, what do we do? Can a contract be saved even if it is not sufficiently certain from the outset? Once we've considered certainty, we'll then look at the issue of completeness and whether a contract is sufficiently complete or whether it's not complete. And in particular, we'll look at the distinction between what we call an agreement to agree and an agreement to negotiate. We'll then go on to discuss what's called an illusory promise, particularly in the context of an agreement to agree. And then finally, at the end of this week, we discuss the requirements of what we call formality in relation to certain specific types of contract. Once we've done that, we will have brought ourselves to the point where you will all have at least access to the materials for a thorough understanding of the formation of contracts. Next week then we go on and have a look at the skills of writing a terrific answer to a problem question, and then following that from week 8 onwards we go on to the second half of Contracts A, which looks more at the terms and interpretation of a contract. So let's get underway with this last bit of contract formation. And we're going to start by looking at certainty. Now, I've given you the definition of certainty there. That a contract is uncertain if its words are so obscure or incapable of any definite or precise meaning that the court is unable to establish the intentions of the parties. In other words, if the court has a look at a contract and they can't even work out, the judges can't even work out what the contract means or what it was intended, it doesn't make any sense at all, then the contract is uncertain. Now, it's really important to distinguish uncertainty from ambiguity. You see, any time that a contract comes before the court, there's almost inevitably going to be some level of ambiguity. And the reason for this is that you've got a dispute between two parties about what the contract actually means. So you've got one side saying the contract means this, and you've got the other side saying no, it doesn't, the contract means that. And so the two of them go to court to fight it out. Now, if the two parties are capable of coming up with different reasonably sensible interpretations of the same contract, then there's clearly some ambiguity in the contract. But that doesn't mean the contract is uncertain. And the reason I'm making such a big point of this is that there's a real temptation to look at a contract and say, well, it's not completely clear, therefore it's uncertain. That's not what uncertainty means. If a contract is not completely clear, it might be ambiguous, but that doesn't necessarily mean it's uncertain. To be uncertain, it must be at the point where the court can really find no sensible meaning. And to understand this, we can deal with a case that we really come back to through this week's material, and that's Scammell and Nephew and Alston which is a 1940s case around the purchase of a motor lorry. Now, this was a contract between the dealer and a purchaser, and the contract said that the purchase would be made, quote, on hire purchase terms, end quote. Now, what on earth does that mean? I mean, look, we all have a general understanding of what a hire purchase contract is, of what hire purchase means, but in the context of this specific purpose, what on earth did that mean? Was there a particular company to be used? Who was going to choose which hire purchase company was going to finance the purchase? What charges were going to apply? What interest was going to apply? Did the hire purchase agreement have to kick in by a specific date? At what point was title in the motor lorry going to transfer from the seller to the buyer? Or was title going to transfer from the seller to the hire purchase provider? Can you see how there's a bunch of details that really are quite important, but which were not provided at all in a contract that was spelt out in such simple terms? So there's no way that the parties could have known whether or not the terms of that contract had been breached. And then what happens if no hire purchase provider can be found? Because clearly the intentions of the parties was not to sell the motor lorry for cash money up front. So what do if a hire purchase provider can't be found? Does that mean that the buyer is at fault for not being able to secure a hire purchase agreement? Or does it mean that the seller is at fault for not being able to provide a hire purchase facility? You can see this contract had reached the point where those words, on hire purchase terms, really had no sensible meaning. So they were uncertain. Now, this sort of thing happens a lot more than you'd expect, and it particularly happens in cases where you have what we call standard form contracts, which we'll learn a lot more about in week 11 of this course. A standard form contract is one where the same contract is used over and over and over by a commercial party without making any real amendments to take account of the specific circumstances of any particular transaction. The problem with these is that for some commercial transactions, the standard form contract will be spot on. It will do everything that is necessary. But for others, it'll be completely pointless and it won't do everything that's necessary at all, or it'll say things that really have no relevance to the circumstances that have been presented for this particular transaction. So be careful if you're using standard form contracts. So what does a court do if you've got an uncertain contract? A lot of the time, in fact, most of the time, the court is going to try to find a way to save the contract. I mean, in essence, the court is going to look at the two parties and say, here are two parties who tried to make a contract. Here are two parties who tried to undertake obligations to one another. The problem was not with their intention to form legal relations. The problem may not have even been with offer and acceptance. They may have actually been ad idem in relation to the terms of the contract as written. It's just that the terms of the contract didn't actually in the end mean anything. If we've got this situation where the two parties have tried to make a contract, generally speaking, the court is going to try to support them. So generally speaking, the court will say, okay, let's look at whether or not it's possible for us to save this contract. And there's 4 key ways that the court might do this. First is by looking at whether the contract has been executed. Now, an executed contract is one that's actually been completed. So let's say that a contract was written in a really poor way. It was written by a lawyer who clearly hadn't done my legal drafting course, which you'll all do in second year. Nobody can quite make out what it means, but both parties to the contract kind of understood what they intended. It's just that the lawyer hasn't properly written up the contract to reflect their intentions, and they probably haven't even read the contract since the day that they signed it. They've just gone ahead and done the things that they understood themselves to be obliged to do under the contract anyway. So you get to the point where both sides have actually done the things that they were intending to do. But for some reason or another, right at the end of the process, there's ended up being a dispute. And someone's finally picked up the contract and said, what does this thing actually say? And then they found out that the contract didn't say what they thought, because it was expressed in really, really unclear, uncertain terms. Well, under those circumstances, where both parties have really executed the contract, where they have undertaken the obligations which they had, the court's going to turn around and say, well, look, we're going to save this contract because it has been effectively executed. It's pretty much been done. The greater harm would be done in this situation by trying to make the contract void rather than by trying to fill in the gap in certainty with reference to the things which the parties have actually done. So an executed contract is usually going to be savable. The second thing that a court might do to save an uncertain contract is refer to an external standard. Now, when the court refers to an external standard, what it's doing is saying, okay, we've got this uncertain term. If we look at it in context, if we look at it in the context of the industry or the context of the full circumstances, are we able to see an external standard which might help to clear up the meaning of the uncertain term? So let's say you were lending me your car and I was going to pay you $200 for the use of your car for a month. And we decided that we were going to make a contract, and one of the conditions that you put in the contract was that the drivers must be licensed. And I signed the contract and I took the car away, and 2 weeks later I was involved in a motor vehicle accident in that car, and the first thing the police of course asked me to do was produce my driver's license, and I wasn't able to produce a driver's license. Now you of course are not terribly happy about the condition of your car, and you're certainly not happy that I was driving the car without a license, and you say to me, look at the contract. You said that you would not drive the car unless you were licensed. And so I produce my gun license and say, well, I am licensed. Here's my gun license. The contract doesn't say what sort of license I need to have. It just says I must be licensed. Well, here's my license. Now, of course, the court is going to look at a term like that and say, okay, it's an uncertain term, because it would have been much more certain if the drafter of the contract had said that every driver must have a current valid driver's license. But we can refer to an external standard here, because there is an external standard that says in order to drive a motor vehicle you must have a driver's license. And that standard is clearly the one that was intended to apply in that contract. So they can take the details of that term by referring to the external standard that in this case comes out of statute law. The third option open to the court to save an uncertain contract is to refer to what's called a reasonableness standard. Now, we've come across the concept of reasonableness a few times already in this course. We're obviously applying what we've referred to as an objective test. So the court's going to ask, how would a reasonable person correct the uncertainty of the contract? What would a reasonable person expect that term to mean? And in fulfilling that term, we can refer to the idea of reasonableness and make sure that the obligation which is imposed by the term is a reasonable obligation. I'm really not entirely convinced, I'd have to say, about the reference to reasonableness, simply because it's open to parties, if they want, to make an unreasonable contract. Parties come to a contracting situation with their own subjective intentions and wishes. And the example that I've given in the notes is you might get a situation where a grandfather is selling their grandson a car, and they're selling them the car for $1. Now, according to any standard of reasonableness, one would say that's an unreasonable contract. Okay, it's completely unreasonable to sell a motor vehicle for $1. But the parties are perfectly happy to do that, because what they really want to do is transfer ownership in the car for a nominal fee. So given that contracting parties can and will and often do conduct themselves in an entirely unreasonable way, and that's fine and does nobody any harm, I'm not sure whether there's any real basis for the court to resort to a reasonableness standard to fill in uncertain contracts. Having said that, the only other option to the court may be to make the contract void altogether. So if you've got a choice between a void contract or using a reasonableness standard, I guess a reasonableness standard is better than nothing. The final option which is open to the court is to sever the uncertain terms. Now this doesn't always work, because depending on the nature of the term, severing it might completely change the rest of the contract, and the court will be very reluctant to do that. So the court will say, okay, we've got this uncertain term. If we remove that term from the contract altogether, what's the contract going to look like? If the contract is going to work fine without that severed term, if the obligations of the parties are going to be essentially the same, it's just that there's something about the nature of the enforcement that's changed, well then the court is going to say, fine, let's sever the contract. Let's sever the term from the contract. But if severing the term is going to completely change the nature of the obligations, the court is going to be very reluctant to do it. So severance is a possibility that is open there, but it's often very problematic, because certainly the parties see the term in particular as being relatively significant within the contract that they've made, because if they didn't, well, they wouldn't be suing one another over it. But be aware that severance is out there as a possibility that the court can use. So we had this idea of certainty and uncertainty. The idea is that if there are words in the contract that are so uncertain that the court really can't attach a sensible meaning to them at all, well then the starting position is that not only those terms but the entire contract is going to be void. Realistically, the court doesn't want to go there. Its preference would be for there to be a contract of some sort, because that's clearly what the parties wanted. So the court will adopt one of these four methods to try and save the contract. If it's executed, they'll normally just treat the contract as being saved anyway. If there's an external standard that can help out, then the courts will resort to that external standard. If there's no external standard, then they might impose a standard by looking at a reasonableness standard and saying, what would a reasonable person expect under these circumstances? And finally, if none of that works, they can try and just remove the uncertain term from the contract altogether. And if that happens, and if that can be done without fundamentally altering the obligations under the contract, then the parties can simply proceed. So that's certainty. Let's move on now and have a look at completeness. Completeness is an interesting issue because no contract is ever absolutely complete. I mean, imagine that you were making a contract with a taxi driver to drive you to the airport, and you wanted to try to make that contract complete. What would you have to do? Well, you'd have to write that the taxi should arrive in the front at the front driveway of your home and give the address at exactly 5:30 a.m. on the particular day in question, that the taxi driver should be licensed to drive a taxi in this state and should be appropriately booked on and covered by appropriate insurance, that the taxi driver should then exit the vehicle and assist you to place your luggage in either the back seat or the boot of the vehicle, that the taxi driver should then get back into the seat, into the driver's seat, and put his seat belt on, that he should then ensure that the reverse lights were working and put the car into reverse gear in order to reverse out of the driveway. At the same time, he should be swinging the steering wheel down to the right in order to back the car out to the left. He should then apply the brakes, put the car into drive gear if the car is an automatic transmission, or into first gear if it's manual transmission, and then he should slowly accelerate, not exceeding the speed limit until he comes to the first corner. At the first corner, he should indicate whilst braking, etc., etc., etc. You can see that even a contract for a taxi trip from home to the airport could run to many hundreds of pages. So the reality is that no contract is ever absolutely complete. And you could always criticize any contract by saying this contract doesn't have enough detail, it doesn't go into enough detail. Common sense says that there's going to be some point at which the contract will fall silent. There's going to be some level of detail which we can reasonably expect, but beyond that, it's just silly. It's just silly to expect that a contract is going to be completely and utterly complete. The question that the court will look at when the court is trying to work out whether a contract has been properly formed is whether the contract is sufficiently complete to be enforced. So the court will say, has the contract got enough detail in it that we can properly understand the obligations of each party, that we can properly understand what it is that the parties were actually ad idem about, and so that we can properly understand what it is that the parties, or that the plaintiff party, is actually asking the court to enforce. So the requirement for contract formation is not absolute completeness, it's just sufficient completeness. It is not uncommon for parties to start with a contract that is enough to get them underway, but the contract that is not actually complete at the time. It might be, for instance, that they'll have to wait for specific government approvals. It might be that they'll have to wait for arrangements to be made with suppliers. It might be that they're contingent on the weather. There might be a dozen different reasons why parties might not be able to make a complete contract at the start, but why they might want to make a contract and actually get cracking and get underway rather than waiting for a point where they can make a complete contract. That's fine. It's allowed for parties to make a contract that is incomplete in that way, provided they have established a mechanism to resolve the incompleteness down the track. Okay, so if the parties have written a contract and they say in the contract, look, we acknowledge that there's bits of this arrangement and that some of these obligations can't properly be defined at this point, but we want to get the contract cracking anyway, so we're going to agree to put in a mechanism so that the ambiguities can be resolved down the track. That's fine. The courts will have no problem with that, depending on what sort of mechanism is put in place. The golden rule is that you cannot have an agreement to agree. So if the contract says the parties will agree on the final price by the 30th of December, you've got yourself an invalid contract, because there's no way you can predict that the parties will agree. Anything that is premised on the parties coming to an agreement is going to be invalid, because history shows us that even the best of parties quite often fail to come to an agreement when the chips are down. So you can't agree to agree. You can, however, agree to negotiate. Because agreement to negotiate doesn't put either party under an obligation to come to an agreement. It just puts the parties under an obligation to come to the table and have the discussion. Now, what that might mean is that if the parties negotiate and they fail to make an agreement, that the contract might be uncertain or incomplete at that point, and it might be necessary for them to look at legal action in relation to one another, and that's probably a good reason for both sides of the contract to negotiate with goodwill and in good faith. But both sides can actually meet their obligations under the initial contract simply by negotiating. So can you see that an agreement to negotiate is fine because it sets out an obligation which can be met? An agreement to agree is not fine because there's no way that a party can undertake an obligation which actually requires them to agree with something that they might not in the end agree with. What other options are there? Well, the next option is reference to a third party. This one happens very often indeed. It's not uncommon at all, particularly in commercial contracts, for parties to say that they have or for the contract to say that there's going to be a dispute resolution mechanism agreed within the parties, or agreed by the parties. So in that clause of the contract, the parties are saying, we recognise that there may be disagreements in the future, and this is how we propose to resolve them. Now that's clearly incomplete, because the parties haven't identified what those disagreements are going to be about. The parties haven't identified what each party's obligation is going to be in terms of the resolution of that disagreement. All they've said is, we realise that there might be disagreements and this is how we propose to resolve them. That's perfectly valid. It's not uncommon, for instance, for the parties to agree that if there's a dispute, it will get referred to an independent third party, an arbitrator or an umpire or a mediator. And that's perfectly valid because you can see that the obligations of each party are entirely clear. The obligations of the party may be to respond to the complaint put by the other side if it's been properly put to the independent third party. That says nothing about the need to actually resolve the dispute, but it does provide a mechanism by which the dispute could be resolved. On that basis, the court would be perfectly happy with the contract and would be perfectly happy to say that it is not void for incompleteness. What if a contract is incomplete, but it allows for the resolution of that incompleteness by giving one party a discretion? Now, this is really common, and the place where most people would run into this most obviously is in contracts for a home loan. If you sign up with a contract for a home loan, particularly if you're signing up for a home loan on variable interest, then somewhere in that mortgage document you will be giving the bank the discretion to change the interest rate. So the contract will not say this is what the interest rate is going to be for the entire 25 or 30 year period of the home loan. What the contract will say is, this is the initial interest rate, and guess what? The bank can change it whenever it likes. Well, that's incomplete, isn't it? Because a complete contract would tell you what the interest rate was going to be right through to the final amortisation of the contract. But it's not a problematic incompleteness because there is a mechanism to resolve the question of the interest rates, and the mechanism is that the bank gets to decide. Some of you are probably thinking that's a little bit unfair. I mean, it's not much of a dispute resolution process, is it? If the mechanism for resolving disputes is to say, well, one party gets to decide and the other party can go jump in the lake. And you're right. It's not much of a dispute resolution mechanism, but it is a legally valid one which parties are entitled to enter into if it works for them. There are, however, limits around it, and a discretion can't be given to a party if the discretion is going to make either party's promise illusory. And what do we mean by that? What's an illusory promise? Well, an illusory promise is one that lets you abandon your obligations altogether. So an example of an illusory promise might be, I will mow your lawn, you will pay me $20 and I will mow your lawn unless I decide not to. Now you can see that there's a discretion there, unless I decide not to. But the problem with that discretion is that it completely allows me to withdraw from my obligation. So it gives me a discretion as to whether I will perform my obligation under the contract or not. Now really, if you have a discretion as to whether to perform the obligation or not, it's not an obligation, is it? I mean, if it's something that you're essentially volunteering to do because you can at any time just simply decide that you're not going to do it, well, we're no longer talking about an obligation. And in that case, if there's no obligation to act, no obligation to forbear, and no promise that can be enforced, then you haven't given consideration for the contract. And if you haven't given consideration for the contract, there is no contract. So you can see that once you start to get an illusory discretion, once you start to get a discretion that allows one party or another to make their obligations magically disappear, you don't have a contract at all. So when we talk about completeness, the things we need to remember are, first, that no contract is ever absolutely complete. Second, that completeness is allowed because quite often parties can't see into the future, but there needs to be a mechanism to allow the parties to resolve any disputes about that incompleteness. And there are two things that mechanism can't involve. First, the mechanism cannot involve an agreement to agree. Second, the mechanism cannot give one party a discretion which is so broad that it essentially allows them to abandon their obligations under the contract. Alright, this is the very last slide in our study of contract formation. This is about formalities. There are certain contracts that have certain formalities which are imposed. Now, the oldest of these is contracts for the sale of an interest in land. That's required to be in writing by an ancient statute called the Statute of Frauds, which has been updated and is now encaptured by various pieces of property legislation around Australia, and you'll learn much more about them when you do property law. However, when you do property law, the lecturer will no doubt say, recall your study of contracts and recall the fact that a contract for the sale of land must be in writing. You cannot have an oral contract for the sale of land. There are other types of contract that have specific requirements. For instance, if somebody shows up at your door and they offer you a new electricity service or a new phone service and you sign up on the spot, there will usually be a requirement for a cooling off period. There may be a requirement for the company to present to you certain documents to allow you to consider them. If you're going to get a loan, there's now a requirement for a comparison interest rate to be shown to you. If you're going to invest, then there's certain documentation that has to be shown to you before you go and invest your money in any investment scheme. So there are formal requirements for some types of contract. If those formalities are not met, then contract formation has failed. So you don't even need to look at whether either party met their obligations under the Act or not, because there's not a contract. There's not a contract in the first place. So if there are types of contracts that you know have formalities attached to them, then as the final step in assessing contract formation, you need to have a look to make sure that those formalities have been complied with. So let's review, and let's start at the start. Let's review everything. We started our look at contract formation by examining the issue of capacity. And we said the law protects people who, for one reason or another, essentially lack the capacity to make a contract properly. That includes young people, people who have a temporary mental illness, people who are intoxicated through either drugs or alcohol. The general rule is that people without capacity are unable to consent to contracts, but that's not entirely correct because there are plenty of exceptions. And so we learned about exceptions like the provision of necessaries for a minor and the provision of contracts of beneficial employment. And we learned that the test for intoxication is whether or not the person making the contract is able to understand the nature of the contract and able to give their agreement to it. We then went on and looked at the intention to create legal relations, and in order to do that we divided contracts up into social and commercial contracts, and we said that for social contracts the presumption is that the contract is not going to be binding, but you can rebut it, and for commercial contracts the presumption is that the contract will be binding unless you can show that there's an honour clause. We then went on and looked at the concepts of offer and acceptance, and we said that an offer is a statement by a party that they are willing to be bound by the obligations which are set out in the offer. The offer can be made bilaterally to an individual or small group, or it can be made unilaterally to the whole world. We distinguished an offer from an invitation to treat, which is merely a statement that you're open to offers. And we looked at the ways that an offer can be withdrawn. We then looked at the idea of acceptance, that an offer, in order to become a contract, has to be accepted. That acceptance has to be unconditional. The parties must be ad idem, they must be of one mind. The acceptance must be in the form that is required under the contract, and you can't put in as that requirement acceptance by silence. We then looked at the idea of consideration. We looked at the concept of nudum pactum, which is a naked promise, a promise that the person who is receiving the benefit of the promise has done nothing to earn. And we said that that person really can't enforce the promise because they haven't done anything. They haven't given anything in exchange for it. Consideration, however, has a number of rules. Consideration is the price that we pay for a promise, but consideration can't be past consideration. It has to be bargained for. It can't just be the completion of an obligation which you already had under an existing duty. And consideration has to have value, but the value doesn't have to be equivalent to the value of whatever obligation is being purchased. And that brought us to this week, where we looked at certainty and completeness. We started out with certainty, and we said that a contract is uncertain if the court cannot attach any real meaning to it at all. But the court's still going to try and save an uncertain contract if it can. It's either going to say the contract's been executed, so it's fine, or it'll refer to an external standard, or it'll refer to a reasonableness standard and say what would a reasonable understanding be, or it will try to sever the term altogether. It's only if none of these things will work that the court will say the contract is uncertain and therefore we're not going to enforce it. We also talked about completeness and recognised that no contract is ever absolutely incomplete, and that it's quite common for parties to realise that they can't see into the future, and so they make a contract which is knowingly incomplete, but which allows them a mechanism to resolve any disputes into the future. We looked, however, at the fact that there are two mechanisms that parties can't prescribe. They can't agree to agree, and they can't give either party such a broad discretion that that party's promises become illusory. In other words, you can't have a discretion to just get out of the obligations which you had under the contract. And the very last thing that we've spoken about in our study of the formation of contracts is what we call formalities. That there are certain types of contract that have stipulated requirements that must be met. Usually the requirement to produce certain aspects of the contract in writing. And a failure to meet those formalities will mean that contract formation has not been accomplished. So at this point, you understand the formation of contracts. You can look at circumstances where there is purported to be a contract, and you can at least answer the question, is there a valid contract? Now, next week we're going to talk about skills, and then when we return to contract law proper in the following week, we're then going to say, okay, now we've got a valid contract. We've looked at the contract formation. We know there's a contract there. The next stage is to say, what does the contract actually mean? How does the court work out what the meaning is of the words of the contract? Once we get to the bottom of that, you'll be finished contracts A, and you'll be ready to head on to contracts B and look at the execution of contracts, breach of contracts, and the remedies when a contract is breached. I look forward to talking to you all next week about how to write great answers to problem questions.